A murder trial is underway for 3 white Georgian men accused of killing 25-year-old Ahmaud Arbery, who was black. Today, jurors began listening to opening statements, despite allegations of discrimination in the jury selection process. 11 out of the 12 jurors are white, only 1 is black. Travis McMichael, his father Gregory, and their friend William Bryan have pleaded not guilty to killing Arbery. The men claim they thought he was a burglar and chased him through a mostly white neighborhood before taking his life in a struggle. The shooting happened back in 2020. Arbery's mother says her son was just out jogging. She says prosecutors told her the case is strong.
Lots and lots of evidence. They're really not satisfied with the jury that has been selected, but they're sure that the evidence will prevail.
For more on this, I want to bring in CBS News legal analyst Rikki Klieman. Hi, Rikki. Great to see you. So defense attorneys struck 11 of the 12 black jurors from the final jury pool, which even raised eyebrows with the presiding judge, Timothy Walmsley. He said, quote, "This court has found that there appears to be intentional discrimination in the panel," end quote. So, Rikki, why is the judge allowing the trial to move forward?
What happens in the state of Georgia, as in many other states, is when there is what we call a reverse Batson challenge, which is a legal term having to do with a case involving a person named Batson. It has to do with challenging jurors simply on the basis of race. And the reason it's a reverse Batson challenge is here it was a challenge against the defense. In the old days, Tanya, what would happen is that you would have the situation where a prosecutor did not want African-American jurors because the prosecution in the old days believed that African-American jurors would acquit. Here we have exactly the opposite problem because you have an African-American victim and you have 3 white defendants. So how do these white jurors, that is 11 out of 12, get to sit? Well, all of the prosecution's objections may have been well taken. However, the defense only has to do one thing. The defense has to show that there was a racially neutral reason, that is, to challenge them. So in this case, the defense had some good arguments. You had one person who was African-American who was engaged to someone who had a Facebook page that said, "I run with Maud," and who was therefore, according to the defense, biased. You had another African-American juror who said that he wanted to keep Ahmaud Arbery's name alive, and so on, so that the defense could give a reasonable basis for challenging these black jurors. So the judge really had no choice, that if there is a reason on the record that could be seen for something other than race, the judge in Georgia had to allow the 11 whites and 1 black to sit. While saying that, Tanya, I should add this. There has been an immediate supposition on the part of almost everyone that white jurors would vote to acquit here and that the black juror would vote to convict. However, we have often seen, and certainly I say as a lawyer, that particularly in the protests of 2020, that so many people involved in the protests, involved in Black Lives Matter after the murder, the horrendous murder of George Floyd, what we have seen are so many white people who have joined the cause of Black Lives Matter and have protested. So we should not prejudge all 11 of these white people to simply say that because they are white, they will acquit.
Absolutely. At the same time, I'd like to point out that these jurors who were released because they had, say, posted something on their Facebook page that appeared to be in support of Ahmaud Arbery or their fiancé had, it's a lot easier to go public with those sorts of sentiments than if someone, let's say, harbors racist sentiments. They might not bring those forward. There might not be a Facebook post, indicating this. So that makes it a little harder for the attorneys to tease out.
Well, there is no question. You know, we say that we are in search of a fair and impartial jury. That is exactly the phrase we hear with every trial. But the truth is, we cannot really ferret out everyone's bias. And when we look at real bias, it's often well hidden. And that someone who appears to be totally unbiased may actually be harboring some very racist ideals. So the best you can do is with what is public. Now, at the same time, you could simply have, as a defense lawyer, a reason for challenging a juror of simply saying, I don't like the way that prospective juror looked at my client. That could be enough. And certainly that does not tell us anything about that juror's hidden bias. One of the things we've learned a lot about that has become a phrase in the last couple of years, if not before, is the whole phrase of implicit bias. That is, we all walk around with certain biases. The job of each lawyer during a voir dire process, that is a jury selection process, is to try to dig deep and to try to uncover as much as they can. But jury selection is an art form, and there are very few lawyers who do it very well.
A tricky process and an imperfect science, for sure. Rikki Klieman, thank you so much for joining us. As always, we appreciate it.
Thank you, Tanya.